Alex here with part 135 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex-parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We now go into my motion for costs, hot on the heels of the previous video, which went into the hearing. At the end of that hearing, you saw me ask the court if he wanted me to argue costs then, orally, or if he wanted me to file a motion. He said file a motion, and so here we are with me filing a motion. My, I guess you could say mindset at the time was, it was elated because I finally got the writ of mandamus that I've been wanting all this time. With regards to the motion for costs, I didn't really think that he was going to grant it. I suspected he would deny it. And I actually was building the motion for an appeal because of my suspicion that he was going to deny it. It's an appeal that does end up being filed, and it's my first appellate victory. So that is going to be a small positive, even though the monetary award is low. I have stressed this a number of times to my viewers to take a look at the video. There is a video that discusses, I can't remember now. In fact, I'm going to try to edit in a slide, so it'll probably pop up over here, or actually, yeah, up here somewhere. Go ahead and click on that, and that'll take you to the video that I'm thinking about. It basically talks about how in some situations you have a low reward, but the chance of victory is so high that you may as well do it. So it's a low reward, but low risk. So why not? And that's the particular situation that's going to come up on this appeal. It's that I was guaranteed to win the appeal. So even though the amount was low, I still went ahead and filed it. In other situations, there may be a low likelihood of success on appeal, but the stakes are so high that it's worth taking the risk. Anyway, I talk about that in that video. I think at this point in time, we should just go ahead and take a look at what I have filed. Here we have my motion for costs. Scrolling down, you can see standard introductory paragraph. I identify myself as the petitioner. I indicate to the court that I am appearing a proper person, which means I'm representing myself, and then I'm filing a motion for costs. Okay, factual background. And let's see if I actually kept the facts narrowed to just the purpose of the motion. So number one, May 3rd, filed the application to proceed in forma pauperis. May 13th, the chief judge entered an order allowing me to proceed. May 15th, I initiated the instant special proceeding by filing the petition. October 10th, I filed and served the notice of hearing. November 22nd, the court convened for an evidentiary hearing. Actually, it was a bench trial. On the writ petition, I appeared in proper person. My ex appeared. Oh no, the government appeared through and by its attorney, and my ex failed to appear. Legal analysis. In the instant case, I got a judgment and I prevailed. And I talk about the case that discusses the definition of a prevailing party. The appeal is going to hinge on what a prevailing party is, guys, so pay close attention to this case law. My instant writ petition is a special proceeding, which is defined under this other case. So we've got the first case that I cite defines prevailing party. The second case that I cite defines what a special proceeding is. And then I lead right into the statute, Nevada Revised Statute 18.020 subsection 4, which states that I am entitled to costs as a matter of right. It says an award of costs is mandatory when you prevail in a special proceeding. This judge does not understand what the word mandatory means, but he will be taught this lesson from the Supreme Court of Nevada. I then request costs in accordance with, and not only this judge, guys, the other judge too. I then am awarded costs, or I'm entitled to costs in accordance with my memorandum of costs. We're going to go over that document soon. Next assertion is that I told the chief judge that I would seek to recompense the court's $250 filing fee if granted forma pauperis status. And then this is another law that mandates the court award costs to the county when the prevailing party was given form of pauper status. Now, the judge screws the county out of this money. Okay, if he wants to do that, that's fine. That's the government. It's not really my concern. But I was at least giving the judge the opportunity and the power to recover the costs that my ex should have been ordered to pay, consistent with what the legislature put into law. Of course, when you aren't aggrieved by the judge's decision, it's not really your right to appeal that specific portion. And in that particular case, his violation of the law aggrieves the government. But it's only $250, so I'm sure they don't really care. Moving into the next section. In this instant case, costs should be taxed against my ex. You know what? The taxpayer cares. I'm not going to get into that, though. Costs should be taxed against my ex. Her role in the proceeding, the government's role in the proceeding was merely observational, and the Supreme Court explains this in Falcone v. Secretary of State, that it's not their fault that they were duped. They had to give the fictitious address to my ex because the legislature didn't give them the power to exercise any discretion. So again, it's not really their fault. They were doing what they were ordered to do by the legislature. If it's anyone's fault, it is my ex. Moving into the conclusion, I made my ex several offers to settle the case early on, blah, blah, blah. She refused to do so, which is pretty typical. You know, guys, Sam Vaknin talks about this. He calls it, and again, I'm not saying that my ex for sure has NPD, but I am saying that, in fact, watch my video, Narcissistic Personality Disorder, because I go into this issue in a lot of detail, and I'm not going to talk about it here. And I talk about this a little bit in another video called evaluating mental health. But one of the things that Sam Vaknin says NPDs do is he says that they will wait and see to see what waiting brings. So sometimes, even if they are in an unwinnable position, they will still not concede it, just in case maybe delaying, dragging things out gives them some kind of advantage that they wouldn't have expected to have gotten. So sometimes they'll wait and see just to see what waiting brings. It's an interesting concept. I'm going into the next section here, which is just the conclusion, where I'm asking for an award of $47.56 in costs for me and $250 in cost to the government. Going into the next section here, verification, which is swearing under penalty of perjury that everything asserted in this document is true and correct. Going into Rule 5 Certificate of Service, which is asserting that this document was mailed to both my ex and the government's attorney. Going into the next document, we have the court's minutes. I don't like to spend a lot of time on the minutes, guys, because the final written order by the court is what will control the case going forward, your ex going forward, or whoever your opponent is. Minutes, as the Supreme Court has said, are not really effective for any purpose. It's kind of just like a rough draft of some notes taken by a clerk who was sitting there. So if you guys would like to take a look at the minutes and you have any questions about them, go ahead and post them down in the comments below. But really, we're going to talk about this a whole lot more when we get to the court's actual order. Next document is the memorandum of costs. This is required by law. So I filed it because that's what the law said to do. In the memorandum of costs, you have to put down specifically what you are charging your opponent for having prevailed in the action. The same law requires your opponent to, if they have any issues, within, I think, 2 days, unless they changed it, within 2 days, file some kind of, I think they call it a motion to retax costs, which indicates to me that I probably didn't even need to file that motion. It was probably on my ex. Well, no, because I would have still needed a judgment. So maybe the motion was necessary. You know, some of this stuff is so technical, guys, and I often wonder about it. In any event, I was able to get the award that I needed. These are what I'm trying to attack costs against my ex for. If you want to learn more about what constitutes costs, please take a look at my video, Attorney Fees and Costs, because I go into that. This is something that is very strictly defined. And in fact, the Supreme Court of Nevada has said that an award of costs is, quote, in abrogation to the common law, unquote. And so for that reason, I'm not quite sure 100% what that means and what the significance is, but for that reason, because it's in derogation of the common law. Because it's in derogation of the common law, they construe statutes allowing the recovery of costs very strictly. And so you have to comply very strictly with those laws to actually get your award. If you don't do that, you won't get your award of costs. And yes, you don't have to be an attorney to get cost awards. Non-attorneys can get these. You can't get attorney fees, but you can get costs. Other states may be different. Going into the next section, Rule 5 Certificate of Service, indicating that I serve this document to both my ex and the government. Next, we have my request for submission. And this is, guys, I've gone over probably 100 of these by now. If you want to learn more about the significance of the request for submission, please watch the video, Requests for Submission. The reason I do those reference videos is so I don't have to repeat myself 50 different times in the My Docket series. It's kind of a time saver, and it's probably also an annoyance saver for my viewers. And another certificate of service, NRCP Rule 5, indicating that I serve this document to both my ex and the government. And that's it. Going into the aftermath, I filed 4 documents, but they were all free filings, so I incurred $0 in costs. My ex did not participate, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, well, again, she didn't participate, so she probably incurred $0 in attorney fees. The government did not file anything, so they incurred $0 in costs. They would have had to have reviewed these documents just to make sure I wasn't doing anything crazy or trying to do something against the government, which if you read the motion carefully, you'll see that I didn't. In fact, I stated very clearly in there that I was not recovering costs from the government. And so I think that 15 minutes for the government to just briefly review these documents, put it into their system, and flag it as something that they didn't need to do anything about, I think 15 minutes is pretty reasonable for that for 4 documents. And that at the rate of $250 an hour is going to come to $62.50 for the government. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.